Hi, good morning. My name is Rob Collier. I'm with California Drivers Advocates, and I'd like to discuss with you what is an administrative per se hearing at the DMV and whether or not you need one. First of all, let's define what an administrative per se hearing is. In California, we know that it is not lawful to drive while under the influence of alcohol. If you've been arrested for DUI, you will classically have two battles to fight. There's a criminal battle to be fought with the Superior Court, and then there's a separate administrative licensing battle to be fought with the California DMV. So we're here to discuss specifically what happens at the DMV. If you've been arrested for DUI, the California Department of Motor Vehicles will be intent on either suspending or revoking your driving privilege depending upon the facts in your case. If you have had a DUI arrest and you wish to prevent the suspension or revocation of your driving privilege, then you have a right to conduct an administrative hearing with the DMV known as an APS hearing, which stands for Administrative Per Se. It is run very much like a miniature trial. Now, the question becomes, do you need one? Well, the whole question in there is, how important is your driving privilege? Under a new provision that came into effect in January of 2019, if you've been arrested for DUI, you can prevent the suspension of your driving privilege altogether without an administrative per se hearing as long as you install an ignition interlock device, an IID device, in your car for a specified period of time. So if you've got a first offense DUI and you don't mind driving around with an IID device in your car for 5 months, you don't need an admin per se hearing. But think further, think outside the box. The reason you may want to have an administrative per se hearing is for reputation. Obviously, if you've had your driving privilege suspended, that's going to be on your driving record, and employers can find out about that. Next is the embarrassment of driving around with an IID device in your car for 5 months. Let's say you're a salesman and you got to go out and meet clients and they're going to get in your car and see you blowing a breath device. That may not be the best way to do business. The next thing is, you may not be eligible for the IID restriction. In fact, you will not be eligible for the IID restriction if you are on DUI probation, if you're under the age of 21, or if you are accused of a chemical test refusal. In other words, an officer asked you to give a blood or a breath test and you said no, you will not qualify for the IID restriction. And so therefore, if you want to prevent the revocation of your license, you must conduct an administrative per se hearing. So that's what an admin per se hearing is. There are reasons against conducting one. There are many reasons for conducting one. If you have been arrested for DUI and you're trying to consider whether or not to schedule an admin per se hearing, number one, remember, you must take action within 10 days. And number two, give us a call. Let us talk through the case with you. Let us assess it, and then we can give you advice going forward. Thank you.